Welcome everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. I'm Senior Staff Attorney Susan Ingalls here in the background with our producer Kenneth Elliott. You are viewing live South Carolina Legal Services Attorney Kirby Mitchell, Director of our Medical Legal Partnership. And with Kirby today is Attorney Jay Anthony. Jay is a litigation attorney here in Greenville, South Carolina. He practices in a variety of areas of law, including personal injury, construction law, business litigation, and appellate law. Today, we are delighted that Jay is joining Kirby to talk about a really important issue that we see a lot in our housing practice here at Legal Services: mold. Is your apartment making you sick? Here are the basics you need to know to see if there's anything you can do about it. So we appreciate y'all being here with us today. But before we get started, we do want everyone to know this is not legal advice. It is just general information for the public. If you need the help of a lawyer, you can call our intake line here at South Carolina Legal Services or apply online. That information is going to be provided for you on a slide at the end of the presentation today. Also, as a reminder, all of our episodes are posted by our wonderful producer, Kenneth Elliott, to our YouTube channel on the Level Up Law playlist. So you can check out this presentation there and others. We have well over 100 episodes at this point. Now, you are looking at your screen, which has a QR code. If you want to scan that QR code, you can sign up for our newsletter here at Legal Services, and we can get you on that list, and you'll start getting a copy of that every time it comes out. Okay, now our presenters can answer general questions for you guys if there is time during today's presentation. So if you have any questions about this topic, please do put them in the question box. It should be on your screen there. And again, we will post a recording of today's episode on the YouTube channel, but also be sure to check out all of our social media. Like, subscribe, follow, friend, get all the up-to-date information that we provide here on Level Up Law. And you can find all of our other resources to help folks out in the legal world. Those websites and the social media handles can be found on the last slide in today's presentation. All right, you guys, I'm going to let you take it away.
Great. Thank you so much, Susie. Appreciate the invite here to Level Up Law. Thank you very much, Jay Anthony, the private attorney, joining us today. Y'all, we want to just talk about what is a pretty common fact scenario we see: folks having problems with mold in an apartment. Kind of give you just let you kind of listen in as a legal aid lawyer. That's me, Kirby, and Jay Anthony, private attorney. Kind of talk about how we think about these cases, some of the experience we've had, good and bad, kind of just a general overview, how you, a renter, kind of faced with this situation, of what you can kind of start to think about, how we're going to think about these types of cases. We'll give a little overview of the law that's involved, generally, some of the factors and elements we think about with these cases, what type of mold, what's the source, the time frame, what's the goal, and then just a few other important considerations, things we've kind of learned along the way. So the first thing we start with, as we do with most every case, is what law is going to apply. You might think, oh, there's probably some federal law that deals with mold in rental apartments. Not exactly. So Jay, why don't you where do you start? You're here in South Carolina, practicing in the upstate. What law is going to be the first source that we look to when someone presents a case where we think there's mold in an apartment?
Yeah, thanks, Kirby, and thanks again for letting me participate. I think this is a real important topic. It's something I get questions about very frequently, so I know it's out there a lot. The law on this is, we really start with the Landlord-Tenant Act. And of course, a good question at the very beginning, before you really jump into the analysis, is what's the goal? What are we trying to accomplish here? For different clients, depending on your situation, it's different things. You know, some people say, I just want out of this place. You know, my son, my daughter, they're having some health problems. I want to get out of this. Some people are saying, I want to file a lawsuit and I want to, get some damages based on what we've been through here. And so that's an initial question in terms of what you're looking to, but your rights are definitely going to start with the South Carolina Residential Landlord Tenant Act. And that is really a pretty user-friendly statute. A lot of people, your average person without a law degree is going to be understandably kind of intimidated by the idea of cracking open a law book and starting to wade through statutes. But the Landlord Tenant Act is designed to be somewhat user-friendly, and it's pretty readable. It is broken down in sections of landlord obligations, tenant obligations, landlord remedies, tenant remedies. And that's where we start in terms of what the landlord's obligations are in terms of your apartment or your house that you're renting, and then what your remedies are in trying to make your landlord do the right thing. Because if you're on this webinar, you're talking to us, he probably hasn't. And so that's where we start, and then we kind of jump into the specific situations and how to kind of accomplish those goals.
Great. Yeah, so Jay laid it out there. The Landlord Tenant Act, that's a South Carolina state law, and that kind of controls, or generally is where the starting point, any dispute between a landlord and a tenant. And so certainly if there's alleged to be mold, that's the first place we're going to look. I'll just quickly note that that usually means magistrate court for landlord-tenant disputes. There are some opportunities to have the case heard in what we call big court or circuit court, sometimes another state court. But just know that we're probably talking about magistrate court as a starting point, sometimes referred to as summary court. You see, we've got several of these small claims courts or magistrate courts across the county, and they tend to have jurisdiction of landlord-tenant disputes. But if the case involves a fair amount of money in dispute and serious damages, it probably would go to circuit court. I guess there's a possibility of federal court. I don't know, Jay. The Americans with Disability Act is a federal law that, in some mold cases, I've alleged and argued because my client, the tenant, had a recognized disability that needed some accommodation, and we kind of argued that law applied and certainly applies in some contexts. And that kind of leads to the next question: who's the defendant? Who's the opposing party? We say landlord, but just know that that can be a lot of things. I work at the Medical Legal Partnership, legal aid. Most all of our clients are low income, so we have things like subsidized housing, so-called public housing, the Greenville Housing Authority, Section 8. You hear these terms, veterans housing or low-income tax credit housing. So those are what I'm going to call public housing or subsidized, some sort of involvement in the federal government or a housing authority. But most landlords are not that. What's the type of private landlord you see, Jay, in the cases you've heard about or dealt with?
Yeah, jumping off that last point you made though, Kirby, which is a good one, is there could be other avenues for you just other than the court system, other than the Landlord Tenant Act, because the idea, of course, is you put pressure on your landlord to do the right thing here and give you a healthy apartment. So, and Kirby, you know this area better than I do, but in terms of Section 8, I know there are different regulations and oversight boards out there. Same thing with the VA. And so you may be able to get the results you're looking for by going through some of those entities and kind of taking advantage of some of their oversight and regulations in a way that's maybe faster and more effective than trying to do it your own. But back to the question that you asked, if you were in just kind of a regular apartment that's owned by some company or house owned by a landlord, then your defendant is going to be mostly the property owner, which is the landlord. Now, a lot of times those guys use property management groups, and I would include them and go through them as well. But if you actually get to the point where you're at the magistrate's court getting ready to file a lawsuit, then your defendant is most likely your landlord, which is going to be that company that's on your lease. And that's who you need to put down in that box. And that is the nice thing about magistrate's court jurisdiction, is that you don't have to have a lawyer to do this. And the magistrate's court is made for people without law degrees to be able to go in there and file lawsuits and prosecute those things all the way to the finish. Because a lot of these cases, it's not going to be worth a lawyer getting involved, both in terms of the expense to you and you know, kind of the hassle and everything else. And so you can go that route on your own. But I guess to back up just a little bit, you know, before you get to the courthouse, you do need to try to walk through the Landlord-Tenant Act in terms of getting your landlord to fix the problem. And the act, you can find it just by Googling it, and it's worth a read if you find yourself in this situation. But the key components to that are, you need to give notice to your landlord and give him the opportunity to fix the problem.
That's right. That's if you remember nothing else from today and you've got mold and you're angry and you're convinced that's causing health problems for you, do not just immediately stop paying your rent. That then creates a whole nother problem for you that probably is not going to go well. Jay alluded to it. The Landlord-Tenant Act lays out what to do in this situation. You have a right to a habitable apartment. You're alleging that it's not habitable due to this condition. Today we're talking about mold, but of course there's all kinds of things, bed bugs and, you know, the stove not working and no heat. But the code covers this. So you're alleging it's not habitable. You have to give written notice to your landlord of that, written notice. There's some dispute in some courts whether a text message is written and emails, but certainly there's no dispute. If you send a letter, if you send a certified letter, that's what we always recommend. Multiple ways of communicating. Certainly call on the phone if you talk to your landlord, and let them know, and then have documentation and proof that you gave notice. So written notice, Jay said that, and then you have to give a reasonable time for that to be addressed, accommodated. You know, if it's serious mold, it's not going to be fixed overnight, and that can lead to some strategy decisions about what you need to do for your family in that time period. But yeah, that's an excellent point to make right away. There can be different remedies. We talked about you're not going to just file a lawsuit right away, and depending on the type of landlord you have, there may be other ways to address it. Yeah, this is exactly what the lawyers are going to think about first. You know, what law is going to apply? What type of landlord do I have? And then, Jay, I don't know about you. I want to know, let me see this mold, okay? There's different types of mold. I'm not a scientist. I'm not an industrial hygienist or an environmental engineer. Those are the terms for some of the experts we involve in these cases. I think you can buy a mold test now at Home Depot. You know, some clients have told me they've done that. Talk about this step, okay? We've thought about the law. We've thought about the landlord, the defendant. What about the actual mold? What's your approach here?
Yeah, and that's a real important question that a lot of times people jump over, and Kirby and I have talked about this in some detail. But you know, a lot of times I have folks come to see me and they say, well, I've got mold in my apartment, so I want to file a lawsuit. And that's understandable to think that way, but that's really cart before the horse, because there is a lot of different mold out there. And as any mold expert will tell you, there's a lot of mold out just outside. If you walk out the front door of your house, you're exposed to some mold, because that's just a natural part of our environment. And not all of it is harmful, and not all of it's toxic. Some of it is. And frankly, the presence of it in your apartment is not a good thing, okay? And that's something that a landlord should be required to fix. Now, as Kirby and I have discussed, there's not really any good black letter law on that says, you know, if you don't have hot water, the law is pretty clear that that's a violation for the landlord. If you don't have gas or heat, the law is pretty clear about that. There's nothing out there in the South Carolina code that says if you've got mold in your apartment, then that's a violation. But from a practical perspective, if you get into a courtroom and you've got pictures of mold in your apartment that the landlord has refused to address, I don't care what kind it is, the judge is going to say that's a problem. Now, for your own kind of practical reasons, you want to know what it is. And so that's particularly true if you're feeling like you've got health problems or your children have health problems coming from that. And, you know, we should touch at some point later on Kirby's organization and their role in those particular type of cases, because they serve a real important role in the community in protecting the health of families out there. But that's an important thing for you to figure out. And so there are the test kits that you can get, which will tell you what you've got to some reasonable degree of certainty. May or may not be terribly persuasive to a judge, but in magistrate's court, the bar for evidence is a lot lower than if we're in circuit court. So it's probably evidence. You can also go to some of these testing companies, and you can find them on Google, who will come in and do a more robust job and test and tell you from a more expert perspective what you're dealing with and how dangerous it is. Those guys cost some money, and so that's not always an easy thing to do. But I think figuring out what kind you've got, while at the same time going ahead and giving your landlord notice, which starts a 14-day clock for your landlord to try to remediate that and fix it. Those are two important things, and it's good to document. You know, even before you give your landlord notice, you know, take pictures, do that test, even if it's just an at-home test, so you have an idea. Because the next thing that can be problematic is, what is the definition of fixing the problem? And that's where I see a lot of problems in terms of folks coming to me. The landlord's come out and done something, but there's a real question as to whether that's adequate or not.
Very true. I would say regarding the mold, you know, I like to go out and actually see the property myself. I've done this a lot for many years across the upstate, and usually there's mold. We take pictures right away. That can prove a lot. I try to document the source of the moisture. Mold really does require moisture. So if you can show, hey, there's a leaking air conditioner unit, you know, there's water sitting, or you know, some source of water, I would document that as well. You know, photograph that, have evidence about that. So it doesn't automatically, if you have a leak, mean mold, but you really can't have mold without moisture and a lack of ventilation. So be thinking about those elements that certainly pictures of the mold, black mold, that you know, trying to make it clear it's not just mildew. It's not a situation where you just haven't cleaned. I've had that situation where I've gone out and thought, man, someone should just clean up a little. You know, it helps to show that you mitigated, you did everything you could as a renter. But yeah, show the actual mold, show the source of the water, and then some lack of ventilation. You know, interesting, a lot of our modern, wonderful new buildings are more prone to mold in some ways than much older housing stock. How is that possible? You know, housing today is so much more energy efficient and tighter, the actual construction, and people tend to open their windows far less. So if you're thinking back, you know, 100 years ago, some of the housing didn't have mold because there was just a lot of air coming through and ventilation in the sense that we don't have that today. So all right, we've talked about law, we've talked about the defendants, the landlords, the types of mold, some of the documentation, how to prove a case. What else? What's your next kind of thought in these cases, Jay, or some other considerations? I know some people, they have signed something in their lease, like a disclaimer. Is that a thing? Is there some sort of,
because those things are
talk
out.
about those elements, some of these other things that can be barriers or be advantages once you get to this stage. What happens now?
Yeah, so I'm glad you brought that up, because I'm seeing the mold disclaimer more and more. And you know, you sign disclaimers lots of different places. You know, if you go join a gym, they make you sign a waiver that says that you're giving up rights to negligence. And I've signed those before, and then I've told the person behind the desk, you realize this is, you know, totally worthless, right? Because you can't sign away things like that. And mold is one of those things. So they can have you sign whatever you want. I think those are mostly used by the landlords to try to bully people into leaving these sort of claims alone. But the Landlord Tenant Act's very specific that you can't be asked to sign away the rights that are protected by the Landlord Tenant Act. So you can't agree, even if you sign a document that says, I agree that this roof doesn't have to be, you know, waterproof. That's not enforceable, and no magistrate's court is going to allow that. And these landlords can actually open themselves up to some liability by trying to have you sign those sort of things. I've not seen that pressed yet, but I would love to see that at some point. You know, just the idea of having you sign a mold disclaimer, running afoul of the Landlord Tenant Act. So don't be scared off or intimidated by those sort of things. They've still got their obligations under the act. And kind of going back to the point that Kirby was just making too on the source of the mold, it's important to see how they fix it. And it's probably worth documenting how they fix it. The landlord's got the right to try to fix it. And so even if they come in with just a can of Kills, you probably need to let them do it. But then if you feel like that's not adequate, you know, if you know that this mold is being caused by a leak from the bathtub upstairs and they're just painting over it, you need to document the way they fix it, and then you need to put in writing your objections to the way they fix it. And the real reason for that is you're setting them up. And they need to be set up if they're trying to do that. Because a mold caused by just kind of simple negligence, a leak, those sort of things, that's not really actionable in what we call a civil lawsuit. You know, you've got a right to have it fixed, but if you bring that to a lawyer, they're not going to be super excited about some kind of a great case. But if the landlord has sort of willfully taken a cheap fix that they know is not really addressing the problem, then that opens up more avenues for you, because there's language in the Landlord Tenant Act about willful and intentional refusal to meet your obligations here. And that's where I've seen some significant mold cases in the past, is where we've been able to find out there was a history of mold in that apartment that they just kind of painted over and didn't do a real serious job on. Or they hired some company to come in that, you know, a lot of times they make it worse because they try to dry it out. And so I've seen it where they'll turn on the HVAC and open up the windows and put a fan on it. Now they've just blown it all over the apartment. So you want to sort of document those sort of things. And again, we kind of come back to the question of what the goal is, because you could, I think, use that ammunition, so to speak, to get out of the lease and get your deposit back, or, you know, potentially to go through a civil lawsuit. And maybe that's another good thing for us to discuss about when you've got a civil lawsuit and when you don't.
Excellent. Yeah, you know, for me, Jay, the challenging thing sometimes in these cases is proving the causation. I work inside the health system. We alluded to this. I'm a legal aid lawyer, but I'm embedded inside the hospital. Here's my little Prisma badge. So under the medical legal partnership approach, you know, I'm part of that team. So these doctors are constantly seeing kids with asthma or cystic fibrosis or you know, some condition where irritants like mold or other environmental irritants in housing is a huge problem, and it drives them right into the emergency room, right into the hospital. And they can pump these kids full of medications and try to treat it medically, but they really find someone with the skill set of you and me, lawyers, civil lawyers, can really be the best tool to address this, you know, because we can use our skill set to get the apartment improved and the environment improved, therefore less visits to the ER, less medications. But to make that persuasive argument, I need to, like we already alluded to, I need to identify the right law, the right defendant. You know, is this mold? I got to document the moisture of some kind, show the mold, and then show that linkage to the health problem that we're seeing, the damages. Certainly, it's bad to have mold in the apartment anytime, but if you've got a child with asthma and you're missing work and the kid's in the hospital and your kid's missing school, this is when the damages can get really big, and this is when a landlord needs to take urgent action. So let's talk about that briefly. Just how do we show that linkage? What's your view on connecting that? Like we talked about, there's no real national standard on how much mold is acceptable or not. We see some types of cases, dog bite litigation, for example, or bed bugs, where it's just evolved to where there's these sort of general standards that, your dog can bite someone once, but after that, strict liability, you're liable after that. It varies from state to state. But so many mold cases across the country, and yet no real standard for that, and no real guidance on causation and the linkage to that health damage. What would you say on that? How would you let lay people think about that issue?
Yeah, that's an important point, because people often think these cases are simple. I've got mold, my child's been sick. There's an obvious connection there, and there is. Common sense says that there is, but the law is a lot more complicated than that, and particularly when you're talking about a civil lawsuit. And that is where these cases can get complex and expensive, frankly, because unlike a dog bite case, where you can just say, this dog bit me, I went to the ER, here are my bills. You don't need expert testimony or science really to make that connection. You definitely do in a mold case, and it's usually a couple of pieces to it. One being what we discussed earlier in terms of a mold expert to say, yes, you've got mold and this is the type, and these are the possible side effects and symptoms of that mold exposure. And then also a medical component to it of a doctor that you've been to or your child has been to saying, I think to a reasonable degree of medical certainty, these symptoms and these problems are caused by the mold. This isn't a common cold. This isn't just some other malady out there, something that he brought home from school. And so you really do need those two pieces. And the one I've found the hardest is the medical component, because doctors don't always have enough information to where they can feel very confident to connect the dots there. And so the obstacle that poses to me as a private attorney is I've got somebody who's walked into my office with what looks like a plausible case, but it's going to take a significant investment of cost to get a mold expert and a medical expert to connect all the dots. And so I run into the case frequently where I think there could be something there, but from a resource standpoint, it's very hard for me to push that along. And that is where Kirby's project really steps into the breach. And so and I've had a couple of cases lately where I've been scuffling, trying to figure out how to help somebody because of those kind of cost obstacles and things like that. And then Kirby has been able to step in and take that through the medical legal partnership and press that and get a good result for the client. So it might be a good moment, Kirby, for you to talk, if you don't mind, a little bit more about how you get connected with those cases and what you're able to do to kind of get that beneficial result for some people and for Prisma.
That's great. Yeah, I appreciate that. That's great. I think, our medical legal partnership, in fact, Susan Ingalls developed a whole Level Up Law episode on that. So if you really want to learn more, she'll tell you how to do that here in a minute as we wrap up. But yeah, the medical legal partnership approach, you take people like me and Jay, people with these skill sets of dealing with landlords and knowing the law, and you sort of use that person inside the health system as another tool for the physicians that are seeing these problems. The real time to do this, if you've got a young child with a diagnosed condition like asthma or some sort of issue with breathing, man, it is important those first 8 years of life. you've got to keep them away from smokers. You've got to keep them away from, pets with hair that causes allergic reaction, all the things that all parents do. But man, you've got to keep them away from toxic mold that can really, really cause lifelong detriment to their breathing development and certainly pleasure of life and ability. So yeah, the Medical Legal Partnership really here in South Carolina in the upstate since 2016, but across the country since the mid 90s, really has proven valuable to those type of physicians. The pediatric pulmonologists, they really love the idea that they have this tool that they can send out into the world outside the four walls of the hospital, as they say. They can keep these kids well inside the hospital, but as soon as they send them back to a moldy apartment, it's tough. The causation issues, there are so many factors. I have gone to an apartment once thinking, oh, there's going to be mold. And I think there was, causing maybe this 3-year-old to have terrible breathing problems. But there also were 2 smokers in the house and 3 cats. And so, that's where if you get in front of a jury or you take the case to court, it's a little complicated to demand that, everyone draw the conclusion that the mold is the cause of this child's breathing problem. There's a lot of factors and moving parts. So those are the challenges. That's really just kind of a quick hit on what I want the general public to know. When you have mold in your apartment, you're a renter, you're upset about it, you're going to reach out to a private attorney like Jay, or you're going to be connected to a legal aid lawyer through a medical legal partnership like me. These are the ways we think about the case. We kind of gave you an overview of the law, the defendant, the mold issue, so some of the details, some of the concerns that we worry about make a case weak or strong. So Susie, do you have any questions from the box that any listeners sent to you? We're happy to take those, or any questions you have. But really appreciate the chance to talk to folks through this excellent resource, Level Up Law, and happy to respond to anything that any listeners have.
All right, thanks. This is terrific information. There is a question. If you're asking for money to fix the problem, how do you know how much to ask for and how it can be fixed?
Great question about damages. How would you answer that, Jay?
So if you're asking for money to fix a problem, I'll tell you first that that's really sort of outside the typical routine under the Landlord-Tenant Act. You don't really have a right to ask for money. The way the Landlord-Tenant Act works is that you've got the right to demand action, and the landlord's supposed to take that action. And if he doesn't, you've got the right to terminate your lease. There is something of a self-help remedy for some other conditions called essential services, like if your heat's out, your hot water's out, that sort of thing. But in the context of mold, you're really kind of limited to asking the landlord to take action. And I would prefer it, frankly, because if you start agreeing to do the work yourself, I'm going to take some money from the landlord to get a contractor in here, or to get some Kills paint or something to put on it, you're sort of taking some ownership of that needs to stay with the landlord, frankly. And so, but if you're in that situation and for whatever reason you've decided that's the way to go, then it's just going to depend on a case-by-case basis. But I think you got to drill down to what Kirby was talking about, which is that mold came from somewhere. There's a source. And so you got to identify what the source is. And so then from there, you're going to know how expensive it is to fix it and how much money you need to get that done.
I think that's a great answer. I would just add, we've had some cases where, we put the landlord on notice. They have a duty to address it. They did not. Then you enter the world, sort of what we call a tort or negligence case as well. They have a clear duty, they've breached that duty, and then you get to lay out your damages once you make that argument. So if I had a client who had to move out to another short-term apartment, and we asked that the landlord pay for all of that. Certainly had medical bills that from that point on, we felt like the landlord had some responsibility for. So there is, those are considerations that an attorney should really help you with, knowing, what damages are allowable or what would be reasonable. Some folks, allege pretty serious emotional distress and sort of things that are hard to put a receipt to, but those can be legitimate in certain circumstances. You're allowed to ask that. And if it's in a really egregious case, rare, but a jury or a court could find, punitive damages. If a landlord is very blatantly ignoring the law and their responsibilities, certainly that's something that could come into play. But those cases are rare, I think, realistically, unless you have a big apartment complex with multiple units dealing with this. You might see that more often. But like Jay said, a lot of these cases, it's a situation where we just want the landlord to do what they're supposed to do under a lease agreement, provide a habitable apartment. That may be expensive for them, but that's what happens when you're a landlord. You have to provide habitable places for folks to live, to have a right to get that rent. So that's kind of how we look at those cases on what to ask for.
Okay, great. There's one more question here, but before we get to that, I do want to mention, Kirby, you mentioned we do have a Level Up Law episode that talks about the medical legal partnership and what you guys do. So I definitely want to refer people to that. Also, we do have a video on actually an online classroom about getting your landlord to make repairs. And this is one of those kind of repairs, although it's a very specific area to the area of repairs. But so definitely suggest that our viewers and listeners check that out. Here's the question. What are the names of the specialists who help determine the type of mold that is present? I know you mentioned just you can Google that, but what exactly, I guess they're asking, what exactly are you Googling? What are they called?
I've hired a industrial hygienist, and that was the first time I'd heard that term. It was an environmental engineering firm, and that's the title that they had for that person who came out and did quite a bit of testing. I think it was about $2,500, the cost, but they were certainly ready to, they had a 15-page report and they were ready to come to court. And so it was an industrial hygienist. I don't know that that's the only expert. Jay, what would you say?
Now, I think that's the right search term.
Okay.
There are definitely a handful of them out there that'll do that work. I can't recall any names right offhand. I will say, as I sort of alluded to earlier, I would steer away from the guys you see on TV, that do just general water cleanup and things like that. Occasionally they have somebody who really knows what they're doing. I won't throw any names out there, any companies under the bus, but I've just seen a lot of those companies come out and make it worse and not make it better. So I do think it's worth getting somebody who's a specialist in the area and frankly insisting on that with your landlord too.
I will say one of the great advantages, I think, of the medical legal partnership, the cases I've had, I'm still connected to and working with the pulmonologist staff, and they have told me what the remedy should be. Replace this carpet with this type of tile, or, here's the type of filters, these HEPA filters, this is what this child with cystic fibrosis would benefit from. And, it wasn't all common knowledge. It was things that were kind of specialized to their expertise. So, yeah, I think the types of experts or that could be involved in these cases, finding a remedy or even determining what mold is there, there's kind of a variety still, perhaps, that would be relevant for something like this.
Yeah, well, that's really good information. I know that people who are watching this or will be watching it on YouTube will that actual terminology will be really helpful. Okay, well, I don't see any more questions, but I do want to thank you guys for a really great presentation. Very important information on an important issue. And also, we thank our audience for joining us today and here each week on Level Up Law, as well as on our YouTube channel if you're just watching a replay. We appreciate you being here. And I am going to show my screen again so that you can see another QR code. If you've got a topic to suggest for an episode of Level Up Law, scan this QR code and let us know. We're always looking for ideas. We have ideas of our own, of course, but we want to know what you folks out there in the community are needing to know about. So scan that QR code, and then I'll just mention that if you found today's presentation helpful and you know it'll be helpful to others, please do go to our YouTube channel, and that's at South Carolina Legal Services, and like this broadcast and share it with others who you think it might be helpful to. You know, we always say that we want as many people as possible to get this kind of important information. While you're there at the YouTube channel, which I will show the screen with all of that information, go ahead and like, subscribe, sign up for those notifications on our YouTube channel. And that way, even if you can't join us live, you'll be able to get a notification every week when we post a new episode. So we definitely encourage everyone to do that. You can see here the information about applying for our services. We have a toll-free number that you can call. You can also apply online. That online is 24/7, so that's a good option. But during the week, Monday through Thursday, 9 to 6, we have our great intake specialists supervised by Managing Attorney Tom Trent in our intake office. So that's always a good option as well. And yeah, just check out all of our social media. We're always putting out great information. And thanks again to Jay Anthony and Kirby Mitchell for really great information. If there's nothing else from you guys, we want to ask our audience to tune in next week for another episode of Level Up Law, Tuesday at noon. Next Tuesday, we have attorney Jack Cahoon from the law firm of Burnett Schutt. Jack will be discussing the South Carolina Wage Claims Act, also an important piece of information. So definitely check that out. Kirby, Jay, anything else from you guys?
Thank you, Susie. Appreciate the invite.
All right. Thanks again, everyone, for tuning in. And thanks to you two for being here with us on Level Up Law. That concludes today's webinar. Take care, everybody.